topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, Tampa, St. Pete. Welcome to another Ask the Expert show, where we bring you the top experts in the field of legal, health, financial, and home improvement. Can you believe we are already at the end of June? That means this is the last Tuesday in June, which means the K. Bender Rimbaum Show, the community association law firm, and we have got one of their finest attorneys, attorney Kirsten Hens. And I have something to share with her. I don't know if she knows this. First of all, welcome back from your vacation, Kirsten.
Hi, Steve. Thanks for having me.
I got it. Well, we love having you, Kirsten. I got to tell you, because we do the show all over the United States. And I got to tell you, and that this is my 15th year, I am seeing more and more law firms change their shingle and add to it and put community association on there, which means there's a lot of firms out there that don't have much experience. Because K. Bender Rimbaum, that is what you have always focused on, community association law. But Kirsten, there's so many firms across the country who are adding this area of law. Did you know that?
Well, I'm not familiar, obviously, with other states, but certainly when I moved to the West Coast, I did notice that there are a lot of firms, at least on the West Coast, and certainly in South Florida, that claim to be experts in
Right.
this area of the law. But this area of the law is very specialized, in my experience, and I've been doing this 15 years with the firm. It takes several years to really learn the law, to dig in, and learn all the nuances. So
Right. Exactly. Well, tell people, because we are getting so many new people who are finding the show. Tell people about K. Bender Rimbaum.
Sure. K. Bender Rimbaum is a community association law firm. So that means that we represent homeowners, condominium, and cooperative associations in all aspects of operating these communities. So I'm what is referred to as general association counsel. So I typically assist boards with the day-to-day operations, whether it's concerns of covenant violations, owners not complying with their obligations, or contract review, rewriting the governing documents, emotional support animals. That sort of thing. But the firm also has a whole litigation team that focuses on dispute resolution, which involves mediation, arbitration, and then litigation, whether it's the association that's pursuing the litigation, or if the association should happen to be sued by an owner. Or a third party like a contractor, and then we have a team of paralegals and attorneys that assist clients with the collection foreclosure part of, condominium governance. So That's kind of how the firm is broken down. We have 23 attorneys on staff throughout the state of Florida. Our main office is in South Florida, Pompano Beach. And then we do have other locations as well. We have a satellite office in Palm Beach Gardens, as well as in the Orlando area. And that is managed by my colleague, Alan, who many of you are familiar with. And then I manage the West Coast office for the firm, which is located in Tampa.
Well, I got to tell you, what is so amazing about your firm, and you're very involved in this area, is the amount of classes you put on. I mean, every month, and we're actually right now, we're actually scrolling your classes, and we'll be repeating those classes because we have so many listeners on radio. There's so many workshops and classes.
That is true. We host a number of webinars each month, and those are typically taught by our community association attorneys in various locations, in person as well as via Zoom webinar style. We take a lot of time to prepare for these courses. Obviously, create the classes. And so, we want to educate board members. Certainly all of our classes are offered for credit. They are approved by the division. And so, we encourage board members and certainly managers to go on our website, check out our schedule of classes, and, attend. These are all free of charge.
Well, let me tell people the ground rules. If you've just tuned in for the first time, we know that the governor just passed some new laws. We're not going to get to those today. We're going to give the firm enough time to swallow these and get to know them so we can educate you. So probably starting next month. So if you've got a question about a new law, we won't be taking those today. We also allow you to text us or email us during the month. And Kirsten, your show always gets a lot of emails. So we're going to try to get all those emails in. If you've got a general question, you could also go to our chat line, our YouTube chat line. And usually we've got enough questions probably to go 2 shows easily. But we're going to get started today. And like I said, we'll go through all the classes will be done. I've promised everybody who's written in that we'll go through those twice a month. Rebel will be going through 20-minute, at the 20 minute after the hour commercial break, so So let's get started. Let's go with Trixie in Tampa. She said, our condo's governing docs were filed in 2002 without Kaufman language. If we revise them in 2025 without Kaufman language, will 2002 or 2025 law apply to us?
Okay. So in this fact pattern, I would say the law that was in effect when the governing documents were initially created is what will apply without Kaufman. But let me, backtrack a little bit and explain for some of the callers what Kaufman language is for those who might not be familiar with this concept. So Kaufman language refers to, these magic words as amended from time to time, which is typically found after reference to either Chapter 718 or 720 or even 719 of the Florida statutes. And you will typically find this reference within the first couple of pages of your declaration, whether it's declaration of condominium or a declaration of covenants if you're with an HOA. So typically you'll see language in the declaration that says something to the effect of, this association is governed under chapter either 718 or 720, and it could say as amended from time to time. So what these words mean is that if you have Kaufman language, then any substantive changes that are made to the Florida statutes will retroactively apply to the association. So that said, if you do not have Kaufman language, then the law that will apply is the law that was in effect at the time of the recording of your original declaration. So in this scenario, the caller mentioned that their documents were created in 2002. They do not have Kaufman language. It seems like the board is looking to potentially rewrite their documents or update them also without Kaufman. And so, she's looking for confirmation as to which law would apply. Well, again, if you're amending without adding Kaufman to it, then again, you would still be subject to the law in 2002, unless you add Kaufman. Now, having said that, if we're talking about procedural changes to Florida statute, those that affect procedure, for example, election procedures or fining procedures or procedure of how you suspend use rights, those types of changes to the statute will apply to your community retroactively, regardless of whether or not you have Kaufman. So.
Okay, let's go to Trey in St. Pete. Thank you, Kirsten, for giving us your time to explain so many different questions. I just want you to know we really do appreciate you and your firm. My question is, why will the DBRP not get involved with HOAs?
Yeah, so the DBPR is it's a regulatory agency that governs corporations in the state of Florida, but in particular, the Division of Condominium is the agency that governs condominiums. For whatever reason, the division, it regulates condominiums, not so much HOAs. There are certain disputes or issues that the division will govern for HOAs, such as elections. But other than that, the division just doesn't get involved. And so with HOAs, that is. And so typically, if there are any disputes in the HOA world, those would just have to be resolved through pre-suit mediation and then litigation if that becomes necessary.
Okay. Lori and Brandon, what can a board do when 100% vote is required, but owners don't participate to vote?
Well, it's first of all, it's unusual that something requires 100% vote. It's not typical unless, of course, we're talking about what is typically referred to as a material amendment. So those are amendments to your governing documents, for example, that change the percentage by which owners pay assessments or voting percentages. So when we're talking about those amendments, typically, yes, they do require 100% approval of the owners. Other than that, very few things require 100%. So I guess I would first suggest for the caller to really confirm the approval requirement for this particular issue. And assuming that it is 100%, or even if it is, a higher threshold, you might want to consider before you even submit the substantive issue to the owners for approval, you might want to consider first reducing the voting percentage Again, depends. If we're
That's a
talking
good idea.
about voting percentage that's set forth in the governing documents, then you might have the option to amend that voting percentage to reduce it to something more manageable, like a majority of the owners. That might require assistance of legal counsel. So if you have one, I suggest that you consult with him or her, and if not, you should have legal counsel to assist with operations. Assuming you can't get the vote reduced for whatever reason, the alternative is really knock on doors. I mean, unfortunately, sometimes that's what is required: knocking on doors, sending email blasts. Really, just try to get owner involvement.
Julie in St. Pete, first of all, she wants to tell you how much she enjoyed going to your certification courses.
Oh.
We appreciate that, and we are going to, I guess this is a board member, we are going to start attending a lot of your seminars. This is Julie in St. Pete. What do you think about a condo property management company not having financials for the past 6 months because they lost an employee? The board thinks nothing of it. I have a problem with that.
Yeah, I mean, it's potentially problematic if the management is supposed to have certain financials prepared for the associations and they can't seem to fulfill this contractual obligation. Certainly sounds like potential breach of this management contract. So, I mean, the board really should be having a discussion with management. And also, I mean, the association is required to have, certain financials, up to date. So definitely start with having a conversation with management. And if this can be resolved, then, potentially look for another management to assist with property managing.
Kirsten, just off the top of my head, how could any association not have a firm, especially a firm like K. Bender Rimbaum? There is so much legalities that an association needs to know about.
I agree with you, Steve. I mean, this area of the law has just become more complex over the years, certainly convoluted as well. I mean, attorneys argue about how to apply this law. So I can't imagine board members try to make sense out of, the statutes and the laws. But also, I think a lot of board members forget that, they are operating a corporation. It's a not-for-profit corporation, but it is a corporation. So aside from the, the laws that govern, condominiums and HOAs and their operations, we're also talking about running an entity, right? That is subject to Chapter 617 of the Florida statute and carries its own set of, issues and responsibilities. And so, boards really need to consult with their legal experts, right? Ranging from not only association legal counsel, but, accountants, management, if necessary, even, engineers, contractors. So yes, definitely recommend having association legal counsel on retainer.
We just got a text from Barb in Tampa. She wanted to know, do you come to the property to make a presentation for an association that's reviewing law firms?
Yes. So yeah, it's essentially, an interview. I mean, I'm happy to either attend in person if they are, within a reasonable distance of the office. But, certainly we represent associations throughout the state of Florida. And as a result of COVID, a lot of boards sometimes even just prefer Zoom meetings. So
Yes.
either way, yes, I'm happy to meet with the board, obviously as a courtesy, and happy to even present a proposal.
We just sent them your phone number for them to contact you. They're in Tampa, so that's your area. Steve in Plant City. When do records become official records?
Well, the way the statutes are currently written, really any record that involves operations of association is considered an official record. So there's no time frame. There's as long as the document relates to operating the association, it's considered an official record.
Okay. Kirsten, we're going to go to break, and before we go to break, give everybody the phone number. Actually, do you have a phone number that's good for all your locations?
Yeah, our main number is 954-928-0680. That's the main number. You call, and the receptionist will just transfer you to my office here or to any other office in Florida.
Okay. We're going to go to break. When we come back, we'll go over your classes and seminars that you're doing in the month of July. We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
And we are back. This is the last Tuesday of the month. Can you believe the month of June's almost gone already? That means K. Bender Rembaum, our community association law firm, and I was talking about at the beginning of the show how they do a lot of seminars and classes, and we've got a list of some of them for the month of June and July. Kirsten, can you give us those?
Yes, Steve. So obviously, we're in the middle of summer. So generally, most people like to take some vacation. So we're a little light in June and July, and then we typically pick up heavily, August and then forward. So for the rest of the month, actually June 22nd, which is this Thursday, I'm teaching Legal Update. Now, this is the legal update of laws that went into effect July 1st of 2024. So for those property managers that are still looking for credits on that, that would be the date to attend. It is a webinar. June 30th, we have Jeff Rembaum and Alan, who will be doing a webinar on association legal requirements with regard to insurance. We have a Castle Association leadership webinar that will be conducted by Michael Bender and Jeff Rembaum. That's July 9th, 12 to 1 p.m. Then we have Educate to Elevate in Broward County as well. This is July 10th. And then July 16th, we have an Educate to Elevate in Palm Beach Gardens. So that would be more of South Florida. These are expos. And then we have the Tampa Condo HOA Expo, October 21st, as well as a Bradenton Condo and HOA Expo on October 29th. And I do typically attend both of these expos as well as teach at both of the expos. So if you are looking for credit or just to, learn, I definitely encourage you to look up the expos and then sign up for the classes.
We just got a text in from Jamal. They want to know, first of all, I just found your show. I'm so glad I found it. What a great show. Can you tell us about what's involved with your expos?
Well,
there's different ones.
Yeah, I mean, these trade expos in general involve, vendors in all kinds of industries, from construction to, landscape to legal, engineering, accountants. So all these experts in their respective fields show up at this trade show, and board members and property managers have an opportunity to walk around, meet these vendors, stop by their booths, talk to them, ask questions. Most of the vendors have goodies. So I know board members love that. And then there are typically classes taught at these expos, not only legal, but I know, for example, engineering firms also teach classes. There's insurance experts teaching. So really just a good venue, a good opportunity to meet experts in this field, ask questions, and hopefully learn.
Yes, absolutely. I'm going to go to Sophia in Tampa. She wants to know, is it legal for two board members to consistently have meetings in the president's home and then vote off a board member without a quorum in his house?
Well, I don't, unless the bylaws require board meetings to be in a specific location, I don't see much of an issue with having the meeting at the president's house, obviously, provided the meeting is duly noticed and the membership has an opportunity to attend and participate at these meetings. So the location is less problematic for me. What is more problematic is that these board members reportedly voted off this other director, which can be done. The board can't remove another director from the board. That is something that can only be done by a vote of the owners through a process called recall. Right. So only owners get to vote for directors as well as remove them from the board. If what we're talking about is the board removing an officer, if this other director was an officer and the vote they took was to remove this individual from their officer position, that can be done, right? Because officers work at the pleasure, right, of the board. So the board elects officers as well as can remove officers. So I would just have the caller confirm, what actually, transpired.
People really like the idea with the website for the community, but they have a lot of complaints about not updating. Here's one from Charlie in Tampa. Our management website could be made better by a first grader. We cannot find any documents or contracts or anything. What do we do to get management more involved in the website?
Oh man. Well, I would I would review the management contract to see, what obligation, if anything, they have to create or maintain this website. Sounds like it might be part of their, duties under the contract. So I would start with talking to management about that. If the website is still not to the standard or what the board likes, then perhaps consider, another vendor to create and maintain an association website. But, it is a problem that certain records are not posted on the website. So that definitely has to be brought to the attention of management.
This question, this email we got, I actually saw it on one of the major newspapers in Florida. It says, can a new owner with dollar laundering conviction 10 years ago from an outside state join the board of directors?
Well, the only qualification requirement involving convictions in the statute is that if the individual that is looking, if the candidate is looking to run for the board, if they're convicted of a felony, right, they are not eligible to run for the board unless their civil rights have been restored for at least 5 years prior to seeking that election. Okay. So those are that's basically what you're looking for. So as long as the civil rights have been restored within the last 5 years, then they are eligible to run for the board.
Phyllis in Tampa, our property managers stated to me that contracts do not have to be on the website. They only need to be list in the contracts. Is that really correct?
Yeah, so the what the statute requires for website is that a list of executory contracts be posted on the website. If you are one of those associations that falls within the threshold of number of units or parcels that requires a website. So, excuse me, you're not required to post a copy of the actual contract on the website, just the list of the contracts. But that is only the website requirement. Keep in mind, the association still has an obligation to maintain copies of all contracts, right? So while not posted, they still have to be maintained as part of the official records. And if an owner does make a written request to inspect the official records, to see a copy of the contract, then the association is required to provide access to those contracts.
Okay. Harold in Tampa wants to know, can the president spend $90,000 painting the roads without a board approval? Is that possible?
Probably not. Probably the president doesn't have a right or entitlement to just unilaterally spend association funds without a vote of the directors, right? No one director should be acting unilaterally. So this is something that will require board vote at a minimum. Now it's a bit concerning that the president wants to paint the roads.
Yes.
So that, to me, if you're talking about condominium, that raises the question of, well, is this potentially considered a material alteration to the existing common elements? I don't know if these roads are owned by the association, presumably. I don't know if we're talking about like a parking lot. If we're talking about this in the condominium setting, then this would likely be considered material alteration. So you'd have to look at your governing documents to see what kind of membership approval, if at all, is required. If we're talking about an HOA, then material alteration is not really a concept of HOAs, but there could be a dollar threshold requirement in the governing documents. So the board can spend up to a certain amount of money on maintenance, repairs, or alterations, and then anything beyond that might require membership approval. So I would just check the governing documents to see if there's any membership approval requirement for this type of project, and you might need to seek legal guidance on that. I mean, that's definitely a possibility.
Is there a difference between paving a parking lot versus paving a road?
Potentially. I don't know if the parking lot would be considered a road.
Yes.
Not sure how big this development is. So unclear if this is a condo or an HOA, but it's not unusual for an HOA to.
It is a condo.
Oh, it is a condo. Okay. Yeah. So, yeah, a little bit odd that we're talking about roads in a condo setting.
Yes.
It could be a big development. Who knows? As long as the association owns the roads.
It's funny. My friend's sister lives at the same community as Alan's family does.
Oh, really?
And they have a long road there. There's homes there and condos there. So that I could see that happening. Let's go on. I'm looking at the chat line. Here's some good questions in here. Here's from Evelyn. We are a small condo association, 60 condos. A new unit owner wants to put a hurricane shutter up and attach to our common elements exterior wall. We denied the new laws. Do we have to allow changing the outside look?
Well, what this is involving is basically hurricane protection.
Mm-hmm.
And the statute was changed last year to specifically require all associations, regardless of when they were created and regardless of whether or not you have Kaufman language in your documents, you are required to adopt hurricane protection specifications, right? Regarding any type of hurricane protection, whether it's hurricane shutters, hurricane impact windows, roofs, so forth and so on. So I think if this is a situation where there are no hurricane shutters currently installed in any of the units, I think the board can adopt hurricane specifications to prohibit owners from installing hurricane shutters. I think if you haven't adopted those specs, it's potentially problematic to now tell the owner they can't install it. But moving forward, I think they need to basically adopt hurricane specifications to prohibit such installations.
Okay. Larry in Clearwater. If the management website does not include contracts, bids, financials for the past 6 to 12 months, and they refuse to produce the requested docs, can we take the board and management to small claims?
I mean, yes, right? You can always sue. Anybody can sue anybody, as we know. But if the owner has made requests for inspection of records and the association hasn't provided access, the owner might also have a basis to file a complaint with the division, right? for failure to access records, and the statute allows minimal damages, right, for the association's failure to provide these records. So filing that division complaint will likely be cheaper than suing the association.
That makes sense. We just here's another question. We do have hurricane. Oh, this is from Evelyn again. They have hurricane sliding glass doors. We do have hurricane spec, I guess.
Specifications.
Yes. I don't know if that helps at all. We're starting to get you know what, Kirsten, we're starting to get a lot of questions in because it's hurricane season. We're starting to get a lot of questions about hurricane, which we'll probably do that the next show. Here's from Joanne. She is a HOA board member. Required to follow through with the motion, or can they change their mind and just not take the action without taking another vote to rescind the action? Wow.
I don't know that I understood that.
I don't know if I understood that either. Let's just go on to the next question. This is from Cindy in St. Pete. Oh, this is a good question. We have a new board member who isn't certified yet. How long do they have to get certified?
Well, if did they indicate if they're with a condominium or an HOA? Condo. So all newly elected directors have to attend a division-approved board certification class within 90 days of being elected or appointed. Okay, so it is a 90-day time frame for newly elected or appointed directors. And I think that this was a situation here, right? Newly elected?
Yes.
Okay. Yeah, so 90 days.
Okay. Oh, here's another good question I've never seen before. This is from Goldie in Tampa. Can anyone who purchases a unit in a 55 plus community, do they have to be 55 plus?
No, they do not.
Ah.
So the age requirement, first of all, this would only apply if your association qualifies as a housing for older persons community, right? So one of these communities, which you have to be at least 55 or older. And there are certain legal requirements that the association has to fulfill in order to qualify as a housing for older persons. And if you meet those requirements, then the age restriction does not apply so much to the purchase of the unit, but rather to the occupancy of the unit. So you could have an individual who is under 55 years of age purchasing and taking title to a unit in a housing for older community. But once that individual purchases or takes title to the unit, if they want to occupy the unit, there has to be at least one other individual who's 55 and older also residing in that unit. So it's the occupancy, not so much the actual purchase of the unit that's an issue.
So a community can't just stick up a sign, we're 55 plus. There's a lot of rules that go into that.
Yeah, I mean, there are certain requirements. I mean, you have to have, for example, your declaration. Your declaration has to expressly state the intent of being a housing for older person, and typically these amendments require membership approval. You also have to have a census conducted every couple of years of all the owners or residents in the community. So yeah, it's not just putting a sign outside the the community.
Are people in the 55 plus, are they allowed to have their grandchildren come in?
Well, one of the reasons that communities, want to qualify as a housing for older persons communities, because they can legally discriminate against families with children under the age of 18. So that is an exemption under the law in which you can discriminate based on age. So if you are a qualified housing for older community, you can legally prohibit individuals under the age of 18 from permanently residing in the unit. Now, many communities do allow, visiting grandchildren to occupy a unit for a certain temporary, limited period of time, typically, 30 days. I haven't seen it to exceed 60 days. So that's okay. That's not going to put the community or the association at risk of losing the exemption. It's when these, grandchildren overstay, right? That could put the community at jeopardy at losing their exemption.
Okay. See if I can get a couple more questions in here. Sunny in Tampa, I heard I should be very careful challenging an ESA application. Is that true?
Yes. You want to be, if you're the board, yes, you want to be careful in, when you review a request for an accommodation to maintain, for the owner to maintain an emotional support animal. Unfortunately, many residents, they know the system, right? They can provide letters from physicians or, medical providers confirming their need for the animal and confirming their disability. And so while the associations have the right to, to do their due diligence, that you want to be careful, right? And so I think the best course of action is just consult with your legal counsel if you receive an ESA application and you have questions.
Kirsten, I got to tell you, I think we've been doing the show with you for about a year now. You do such an incredible job the way you answer questions, and you really take the time to not talk over people's heads, and you really explain everything. And I just want to tell you, I can tell by the letters that come in, people really do appreciate you. Tell people how they can reach K. Bender Rimbaum.
Yes. Thank you, Steve. We try when we give legal guidance to clients, we try not to speak in legalese, right? We're not here. We're not trying to, we don't cite, case law and give, a 10-page treatise on a particular issue. We really try to keep it simple so boards can understand. So, we really try to make it easier for board members. Yes, the main number here at the office is 954-928-0680. And if you call that number, you can reach any attorney at the firm in the state of Florida.
Well, you'll be back again with us next month. And I just want to again just tell you how much we appreciate you, Kirsten.
Thanks, Steve.
We'll see you again next month. Thank you, Kirsten.
Take care. Bye.
Well, that's going to do it for us today. We'll be back again with you next week with more Ask the Experts. Thank you, Rebel.
Thanks for tuning in today to the Ask the Experts show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.